SJC-12458, Essex Regional Retirement Board v. Justices of the Salem Division District Court, Department of the Trial Court, and SJC-12511, State Board of Retirement v. Brian O'Hare.
Mr. Fallon, good morning.
Yes, good morning, Your Honors. May it please the Court, my name is Thomas Fallon. I represent the FAR applicant, John J. Swallow, and this is an applicant for further appellate review of a decision of the Appeals Court, which in itself reversed a decision of the District Court and a decision of the Superior Court, which overruled the Retirement Board. The Retirement Board had found that John J. Swallow had been convicted of a crime that was relating to his official position as a police officer. I will be taking the first 7.5 minutes, and Attorney Tenney will be taking the second. Our argument, quite simply, is that the Appeals Court committed an error of law in overturning the trial courts and affirming the decision of the Retirement Board. The Appeals Court greatly expanded the scope of the statute. The statute doesn't read that way. It was never intended to read that way, and it's a penal in nature, so it has to be narrowly construed.
Did that happen in this case, or did it happen in the Durkin case, that the statute was expanded?
Well, Your Honor, the Durkin case was decided on the direct factual link.
Do you think it's all tied to firearms and it's not beyond the issue of firearms?
Excuse me?
You think Durkin is really focused on obligations of police officers with firearms?
It does, Your Honor, because first in Ghani, this court favorably quoted Durkin under the direct factual link statute, and Durkin was decided under that. In Durkin, the Appeals Court went to great pains to describe the fact that we have 2 Boston police officers. They went to a cookout in the Dorchester section of Boston. They went to a lounge in the Dorchester section of Boston. They were going in a car to sleep over with one officer's house in the West Roxbury section of Boston. And more importantly, he used his service revolver. So Durkin has always been quoted for the direct factual link situation. And in my opinion, if Durkin could have been decided under the so-called direct legal link that they did Swallow under, if that was in fact the case. And when this court in Ghani quoted Durkin, they didn't quote Durkin under the direct legal standard, they quoted Durkin under the direct factual standard. And there's no, in this situation, it's clear, there is no direct factual links. The most important thing is that Officer Swallow had been under suspension at the time that this happened. He was a Manchester police officer. This incident happened in Beverly. It didn't happen with another Manchester police officer. It happened with his wife. There was no service revolver, and he was under suspension. There was no connection at all to his job as a police officer.
Well, you know, it's the intimidation of a witness charge that's a little concerning, though, because the availability of our justice system depends on a number of things, including law enforcement. And to have a police officer charged with intimidation of a witness is a bit of a concern.
I understand that, Your Honor, but the resolution to that concern, I believe, is more aptly in the legislature rather than anybody else. And the legislature could simply, if they so desired, they could amend the statute to say that this applies to any and all conviction of a crime for every public employee, or if they so desired, they could say any and all convictions concerning police officers. They haven't done that. This is under 15.4, and 15.3, the section above, they do mention police duties under embezzlement and use of authority calling for a forfeiture, but they've never done that with police officers. And this court has never held that with police officers. I think.
Do you think informally we have a police officer exception, or I guess formally? We've read in a police officer exception to the statute.
I think the appeals court
I think your
did.
position is wrongly it's been done, but
I think the appeals court did in this case, but this court has never done that, Your Honor. In this court,
haven't come right out and said that. But you think the way the appeals court is interpreted, there is a police officer exception, especially in contrast to the public teacher case.
I think they did, Your Honor, because it seems like they did so in Swallow case and they did so in the O'Hare case. Because in both those cases, what they said was they looked at the so-called special trust, and they said that a police officer's duty is protecting life. And then they read that into it, even though this court has always said there has to be more than just an argument that there's a violation of a special trust. There has to be a fundamental tenet that has to be embodied in a statute concerning the employment, which is what wasn't done in this case. I mean, if you're talking about a special trust and you just look at that term and what that term means, I don't think that anybody would argue that there's no more special trust between a teacher and children. And yet we look at Ghani, and Ghani was a teacher that was convicted of possession of child pornography. Mm-hmm. And the court stressed that it had nothing to do with his position. It wasn't one of his students. And as reprehensible as it was, he didn't violate any fundamental tenet as embodied in a statute concerning his position. And that's what we have here. In the Swallow case and in the O'Hare case, the appeals court did not allude to any statute at all that had to do with this.
You mentioned at the beginning of your argument the standard of a direct factual link.
Yes, Your Honor.
I had read that in O'Hare as being a direct legal link. Do you know if there's a difference or what that would be?
Well, in Ghani, the direct links that this court has required for a forfeiture blossomed into two separate links, the so-called direct factual link, which is the Durkin case, where you have an appeals court mentioning the Dorchester section of Boston, the West Roxbury section of Boston, the serverless revolver, and then you have the so-called direct legal links, and that, I would say, was probably the Bulger case and the Bonomo case.
And then the standard that was used in this case, my memory from the appeals court, I think, was public trust violation and repudiation of official duties, or what were they? What kind of standard were they getting at there?
Well, it's not quite clear.
Is it different than
Yes,
direct
it's not,
legal link?
It's not quite clear what the standard was, Your Honor, but they went to great pains to say Swallow's use of a gun, despite its not being its service firearm to threaten another's life directly, violated the public trust.
Yeah.
By saying that, they're getting away from the direct factual links, because there was no direct factual links.
But is that a direct legal link? I'm
Not-
trying to relate these together.
Not the way that this court has ever interpreted it, Your Honor. In fact, they never even pointed to a statute that allegedly was violated. They're just saying a police officer's duty is to protect life. Anytime a police officer does this, it violates the special trust and he forfeits his pension, which is something that the legislature could very easily do if that's what they wanted to do.
So is it your position that we should abandon the legal links alternative and limit it only to factual links?
It isn't, Your Honor, and I don't think you have to go that far to overturn the appeals court because
So let's assume that we keep the legal links as an alternative. What would be a legal link with regard to a police officer?
there would have to be some type of statute that was directly violated. If you look at 15.3, which is the section above, there is a legal link in that because it mentions 3 separate statutes in 268, and it talks about a violation of police and licensing duties as a forfeiture. But there has to be something, a statute directly in point, and in this case, the appeals court never even pointed to the statute that was allegedly violated. They just said police officer, gun, forfeiture, period.
I mean, but in Bulger, it was perjury in the view that clerk magistrates are swearing in witnesses. That was the legal link.
But Bulger and Bonomo also had the Code of Professional Responsibility in regards to clerks, and that's what this court held was a statute that was violated, and this court said that that's a nexus that was required.
Okay, but you don't want to go there because I'm sure there's code with regard to police officer conduct as well. So if we do that, that's probably not good for your client, would it be?
It isn't, Your Honor, but the Code of Professional Responsibility for the clerks is an SJC statute, so-called, so it would violate it, whereas anything that's absent from the record now could not be replaced with it because it wouldn't have the effect of a statute.
Okay, thank you.
All right, thank you.
Mr. Tennant, good morning.
Good morning, Your Honors. May it please the court, Eric Tennant on behalf of Brian O'Hare. If I could just pick up right there, because I think I have a way of sort of framing this and thinking about it. So the statute talks about your pension is forfeited if you violate a law applicable to your position. And really the question is, what is a law? And the board's arguments in both these cases is the law we're talking about are these workplace regulations, disciplinary code of conduct. That's what they cite as the law that they're saying these men violated. And that's wrong for 3 reasons, and hopefully I think this will address both your questions. Number one, when the statute talks about laws, it talks about, or it means statutes. The first place I get that from is from this court's decision in Finnernan, in which it said as much. It said, when we're talking about direct legal links, we're talking about when a public employee commits a crime directly implicating a statute that is specifically applicable. So that's the first indication that law must mean statute. The second is the statutes themselves, the pension forfeiture statutes. Well, this is chapter 32, section 15.4. It says laws applicable to the position. Within the same statute, section 10, that talks about sort of a different area where you get some enhanced benefits if you retire. There it says you don't get that benefit if you're removed or discharged for a violation of the laws, rules, and regulations applicable to. So now you have an indication that when the legislature says laws, it means statutes. And if it wants to go beyond that, it will write it and say rules and regulations. So now it's the second indication that we're not talking about anything more than statutes. You have to look at what is the statute the person violated. And then the third argument, and I think this gets a little bit into Chief Justice Gantz, what you were asking about, is, okay, well, there are some regulations that have the force of law. And this is, I think, an important distinction between the board's argument and what we're saying. If you accept that the word laws in the statute might encompass some regulations that have the force of law, well, those are not the regulations we're dealing with in this case. Regulations that have the force of law are regulations that go under the Administrative Procedure Act, that has the rulemaking process that an agency is bound to comply with, and if they go through that process, regulations that come from that can have the force of law. But there are lots and lots of regulations that agencies promulgate that don't go through the rulemaking process, that do not have the force of law. And so the code of conduct that the board is citing in this case for both officers, these disciplinary rules, are not regulations in the sense of the force of law. They are.
If they're not in the CMR, they don't count.
Well, it's not that they're in the CMR, it's that if they don't fall under the APA rulemaking process. And workplace rules, disciplinary rules, are specifically excluded from that process under the APA. I cite that in my brief. You can see the APA says, the Administrative Procedure Act says, these rules have to go into the process except for, and then it lists, among other things, disciplinary code, things like that. Because every agency has that. They don't have to have public hearings and go through that process. So even if you accept that some regulations might fall under this, it's the regulations that have the force of law, not the regulations at issue here, not these disciplinary procedures. And it is consistent with Bulger, for example, and even Buonomo to some extent. So Bulger, you have an actual law, an actual statute that the court cites, the obstruction of justice or the perjury, whatever it was. So now you have an actual statute you can look at, and then the court, can make a decision, okay, that statute is clearly related to that. You have these code of ethics, but here's the difference. The judiciary is empowered to make certain rules and codes that do have the force of law. When the judiciary makes rules of court that's said to have the force of law, you are excluded from the APA. So there are 2 paths to make regulations that have the force of law, right? We have executive agencies under the APA that have to go through that process, and then sometimes the judiciary, if you make a code of ethics, for example, or a rule of court. So if you were looking to Bulger and saying it was the statute, okay, we have a statute. If you were looking to Bulger and saying, well, we were really also looking at the code of ethics, okay, well, that code of ethics has the force of law if you're going down that argument. But in this case, the only law, and I put that in quotes, that the board says applies to both parties is this disciplinary code that is neither handed down from the judiciary or made its way through an APA rulemaking process. So you have to go to the statute and say, what is the law? In my case, it's a law that everyone concedes is not, the conviction was, everyone concedes is not related to my client's officer position. They concede there's no factual link. We've never proceeded under that prong. And so the only way the board can come in and say there was a violation is to say, well, he also violated these rules. These rules, these disciplinary rules, are so broad. They cover everything. You could violate the code of conduct by just not being truthful. That's one of the tenets in the regulations. It says every trooper has an obligation to be truthful. And if the board's position was valid, anytime someone was not truthful and there was a finding of such, you could say, well, we're going to violate your pension because you weren't truthful. And you can go through the regulations and see all the tiny little, you have to have a uniform in a certain way.
Let's assume for the moment that we accept your view that it must be a statute, or at least a rule-making rule.
Yes.
Which violations of statutes, if any, when done on an officer's own time with no factual link, would trigger loss of forfeiture?
I think things that deal with, I think Bulger's, things that deal with perjury, things that deal with obstruction of justice, things that deal with impacting investigations, things like that.
I know it doesn't apply to your client,
Yeah.
but that sure sounds a lot like intimidation of a witness.
So I don't know enough about that case. The problem with intimidation of witness, just as putting on my criminal attorney hat, is that can be violated in so many ways that have nothing to do with, for example, lying to a police officer, that it seems like that's so broad, you would want to limit it in some way. I don't know, if it's a catch-all, you have to say one way or the other. And my druthers would be, if you have to say one way or the other because there are ways that it can be violated that don't have to
Now,
do with that.
it's not your client's issue anyway.
Right, but I think that is, and there's going to be statutes where you have that issue.
But how do we draw that line, Mr. Tenen, when we say, if you have the absolutist view that it has to be something that was performed, and I guess if you take away the factual link, we get into
Right.
the legal link now. If you say that, well, maybe perjury, obstruction of justice innately would affect a police officer's ability or is applicable to the office of a police officer, just as we found in Bulger. Where do we draw that line when we try to write this rule?
I don't think you have to draw a line. You go.
But what do we say as far as those core offenses that would lead to forfeiture in a legal sense?
I think you go case by case, and so you have a case in which a police officer is convicted of perjury, and you say, this appears to be one of the laws applicable to this position because perjury involves courtroom testimony and police officers deal with that, and you have to take it statute by statute. That's the only, unfortunately, that's the way the legislature drew it. They said broadly laws applicable to, and then courts interpret, well, what does applicable to mean? And you have to go through each law. And when you look at the laws at issue in this case, I don't think you get there, certainly not for my client. I'll leave the other.
So, in your view, murder would not be disqualifying?
It would not. It really wouldn't, and if the legislature has a problem with that, they can easily fix it, but it is not a law applicable to.
And it therefore wouldn't matter even if there had been a rape of a child in this case, as opposed to...
Again, without that factual link, it's not a law applicable to. Thank you.
All right, thank you. Mr. Sacco.
Good morning, Mr. Chief Justice, members of the board.
We're back to Mr. Swallow's case.
We are back, Mr. Swallow's case. I will take 7 minutes, and my brother will take 8 minutes. The focus this morning seems to be violation of the laws applicable to. But in the legal link, this court talked about violating a fundamental tenet of the position. So clearly, there has to be, based on Bulger, some sort of off-duty conduct under the legal link that would give rise to a pension forfeiture. And what this court said in Bulger, and I'm quoting, "The nature of the crimes cannot be separated from the nature of his particular office when what is at stake is the integrity of the judicial system." In our view, the two fundamental crimes that were committed, I agree with you, Justice Lowry, that the intimidation of a witness crime, although the appeals court didn't focus on that, we think is very significant. The appeals court focused on the use of the handgun. They cited to Durkin, in doing that, Durkin, quite frankly, as a practitioner, was somewhat ambiguous to me when that decision was issued, because they did talk about the service revolver being used, but they discussed the McCatton case, which is always discussed in police officer cases, and if it was that factual link of the revolver, then there was no need to go into all the discussion of the roles of a police officer. So it wasn't until, this court mentioned it in Garney, but in O'Hare, in a footnote, the appeals court said Durkin was a factual link, not a legal link. But is there any more fundamental tenet to a police officer than protecting life? Officer Swallow put a gun in his wife's face in the middle of a domestic dispute, ostensibly threatening to kill her, discharged his weapon, was intimidating a witness, and pled guilty to those crimes in addition to the improper storage of firearms and firing the shot. There has to be a line drawn somewhere, and I understand the court, perhaps, if you're not going to completely back away from the legal link, I think the appropriate line is a felony, because a felony is a disqualifying offense for a police officer. There's your statute, Chapter 41, Section 96A for municipal police officers. My brother will cite the correlating statute for state police officers. If you've been convicted of a felony, you cannot become a police officer. There's your statute.
But the cases reference, and we need to keep in mind that the standard for becoming a police officer or losing the position is not the standard that you apply to forfeiture of a pension that you've been putting in for years, presumably in good standing.
That's correct, Your Honor. And this court, and I think the appeals court, has discussed cases in which someone could conceivably be terminated based on a particular offense, even a criminal offense, but not lose their pension. So I'm not taking an absolutist approach to this. Although when you read Durkin, it says, again quoting, he engaged in the very behavior that he was required by law to prevent.
I guess I have the same issue that Justice Gaziano had, though, which is this just a different standard when it comes to police officers? Because, my goodness, Garney is a teacher, he's a coach, and he's convicted of child pornography. How does that not go to the core of the tenet of, I understand it took place outside of the workplace, but so did this situation.
Well, I think there is a difference between a teacher and a police officer. There are many positions that have an element of public trust.
So you want us to carve out you want us to refine the police officer exception, so-called, and then say, well, we're going to say that when it's a felony, it's disqualifying?
I'm merely suggesting that in terms of looking at a statute, if you wanted to draw that bright line in a felony, I think it would be appropriate.
So if a police officer's mad at someone after getting kicked out of a bar and they throw a rock through a plate glass window, malicious destruction of property over $250, that's a disqualifier for pension?
If you decided that a felony was disqualifying, then yes. We're talking about, first of all, police officers, unlike teachers, have the ability to take your liberty. They have the ability to arrest you. They have the ability to discharge their firearm in the performance of their duties and take your life. They have a higher level.
But isn't the answer with the legislature?
Well, I think the legislature, at least to date, has spoken to say laws applicable to the office or position. This court has taken that interpretation to mean that there is potentially an off-duty legal link component to pension forfeiture, and it's a matter for the court to decide what is appropriate for police officers' off-duty conduct. And I would
But does
say,
it seem odd to you that we have this language, and then we have the language that usually follows in a decision where it says, well, this is penal, we have to construe it narrowly, and then we don't? It's kind of lip service to that notion, isn't it?
well, I'd be less than candid if I didn't say, I've been doing this for 25 years. When the Bulger decision came out, I was surprised.
Right.
Looking at it, but that's because I
Do you
was
think the Bulger decision was decided wrongly?
I think the Bulger decision was a bit of a stretch. But Bulger's not a police officer. There is a difference with a police officer than almost any other public employee, at least in
So
my
if we
view.
stretch, Yeah, if we stretch to get the Bulger,
Right, I'm having trouble with that.
right, shouldn't we correct that? And if, you could speculate the reason why, but shouldn't we fix this?
I don't think that it's necessary to be fixed. I think it's necessary perhaps to be refined and further defined.
Because here we have two very good Superior Court judges, a very capable appeals court, and the cases are all over the place. Wouldn't you agree?
I would agree. I think the cases are all over the place, to use that term, Justice Casianos, because this court has never been faced with a police officer case. You've had other cases. You had the librarian in Scully. You had Garney. You've had the firefighter in Tyler. All of those cases where it was off-duty conduct and there wasn't a sufficient factual link, and the court decided there wasn't a sufficient legal link. With a police officer, I do think that it is a different position, Your Honors, and that they hold a special position of public trust, not just a position of public trust, a special position, as the court discussed in Manhattan. So I think it is appropriate for wherever you decide to draw the line that Officer Swallow's convictions of assault with a dangerous weapon and the intimidation witness are sufficient to provide that legal link for him to forfeit his pension.
Can I ask a quick question?
Sure.
Do you have any thoughts about Attorney Tennant's interpretation of the word law in the statute?
I honestly, Your Honor, I haven't given it sufficient thought or research to properly address it.
It's okay.
Thank you.
Okay, thank you. Mr. Marks, good morning.
Good morning, Your Honors. David Marks, Assistant Attorney General for the Board of Retirement. I have 8 minutes to weigh in on a conversation that could go on for hours, I think. But I want to try to be helpful because the courts have struggled with this statute.
Do you have any thoughts about the about Attorney Tennant's interpretation of the word law?
I want to answer that question first. So when the statute the legislature used the word laws in Chapter 32, Section 15.4, it intended to refer to things that have the force of law. And in all of the cases that both this court and the appeals court have decided, in asking the question, what laws are applicable, the courts have looked at all kinds of things. You've looked at statutes. You've looked at case law. You've looked at the dictionary definition of a teacher in Garney. You've looked at regulations. You looked at regulations in Garney. You looked at court rules. So you were doing that in order to figure out what are the, quote, laws applicable, as that term is used in Section 15.4. The problem with the comparison of this word in 15.4 with the words in Section 10A2, I think it is that the terms laws, rules, and regulations in that section was meant to refer to the bases for termination or discharge. So that statute was meant to cover any ground that an employer might have had to discharge an employee. And that ground could include a personnel manual that does not have the force of law. Clearly, the words laws, rules, and regulations, rather the word laws in Section 15.4 was not meant to exclude regulations, because we all know that duly promulgated regulations have the force of law.
Right, but the problem is the language doesn't speak about simply violation of the laws applicable to his office or position. That is after the phrase, after final conviction of a criminal offense involving violations of the law. And we don't have many criminal offenses which involve violations of regulations, and we certainly don't have those here.
Well, that's not what it's talking about. When it says laws applicable, it means the laws that generally apply to that office or position. without regard to whether they are criminal laws. This is the
But it's
court's
focused on a
point.
conviction. You have to be convicted of a criminal offense involving violation of the laws.
No
Don't you
question
need to
about
focus
it.
on the conviction?
You have to be convicted of a crime. No
Conviction
question.
is almost always going to be a statute.
That's right. But this court said in Gaffney that the language involving violation of the laws applicable was meant to not specify a particular crime. Rather, it was meant to refer to the laws that governed a particular office or position, okay? And that's what this court has done, and that's what the appeals court has done in analyzing questions under this statute. You have asked, what are the laws that apply to an office or position? You haven't asked what crimes apply to an office or position. You've asked what laws apply to the office or position, and how does a criminal violation involve violation of those laws? So in all the cases you have now in Bulger, you have used this analysis to determine whether the criminal conviction violated the fundamental tenets, the central role of the position, as articulated in applicable laws. And for the most part, those laws are things that have the force of law, including your own cases.
Well, can we, on that last point, and on Gaffney, if we just slow down for a minute and look at the statute, as the chief just referenced, after final conviction. So the language as to laws applicable to the position, put aside the appeals court cases for a moment. I mean, in Gaffney, that's not too complicated. He's the head of the water department, and he's stealing funds from the water department. So that wasn't exactly an analysis that tries to distinguish and reconcile cases like Maynard and Durkin.
Well, you do have to take cognizance of this distinction in the analysis that you've used. That is, the legal link line of cases and the factual link line of cases. Now, Gaffney and Marr, another example, were cases in which, yes, the individuals violated laws, right? They committed crimes. But those crimes were not specifically referenced to that employment. Breaking and entering, larceny, they're general crimes. But in those cases, there was the factual connection. In Bulger, this court recognized that there might also be crimes committed off-duty that could implicate the language of 15.4. And in Bulger and Bonomo, the thing you relied on was the code of conduct for clerks and registers, and the provision in the code of conduct that said clerks and registers shall comply with the laws of the Commonwealth. And by committing the crimes they did, in Bulger it was obstruction of justice and perjury, in Bonomo it was larceny, breaking into a depository, that violated the provision in the code that said comply with all laws of the Commonwealth.
So what do you say to be the legal link with regard to police officers?
Police officers are different. No question about it. This court has said so over and over. Here's my, it's a long sentence, but here's my statement of the line, the test. I'm not saying that no misdemeanors will result in pension forfeiture, but in the vast majority of cases, a conviction of a felony by an off-duty police officer, whether a local police officer or a state trooper, will result in forfeiture under Chapter 32, Section 15.4, for three main reasons. One, there are specific statutes applicable to those positions that say police officers cannot serve if they commit a felony. That's Chapter 41, Section 96A. In the case of local police officers, that's Chapter 22C, Section 14. And it's not just that they will be terminated if they do, it's that that law, passed by the legislature, articulates a fundamental tenet of the position. You have to be free of felony convictions to be a police officer. Number two, in the vast majority of cases, a felony is likely to have violated the fundamental tenets of the office or position. For example, because it created a risk to the public, or in O'Hare's case, a risk to a vulnerable member of the public, because it undermined public trust in the position, because it brings the police department into disrepute, because it risked making the officer vulnerable to improper influence and bribery, because it was contrary, directly contrary, to the police officer's role to prevent and investigate crime. Rather, the police officer committed crime and didn't stop the crime from being committed. In Swallow's case, he intimidated a witness rather than supporting a witness, and a felony is likely to interfere with a police officer's ability to do essential functions of the job. Losing a firearms license, not being able to testify because subject to impeachment for a felony conviction. Finally, number three, in the case of the state police, there are rules and regulations that apply that say state police have to do all kinds of things, not bring the department into disrepute, et cetera, and comply with all laws in the jurisdiction in which they are present. And those rules and regulations are issued under statute. General Laws, Chapter 22C, Section 10 says the colonel shall issue rules and regulations for the governance of the state police, and any member of said force violating any of the rules and regulations for said force shall be subject to discipline and discharge in accordance with the rules and regulations. That is about as close to having the force of law as one can get. And under Chapter 30A, because these were rules and regulations for the internal governance of an agency, they did not have to comply with the notice and comment provisions of 30A. But that doesn't mean they don't have the force of law.
But it sounds to me that you're really conflating grounds for discharge, which nobody concedes is different, which is off the table here, with pension forfeiture. Because you've made a nice argument that why you shouldn't be a police officer anymore. But when we have these rules and regulations that prohibit, moral turpitude and the like, how do we not get it to be absolutist so that there's always forfeiture when a police officer does something that someone doesn't like, absent the cruel and unusual issue that we've already dealt with?
Well, let's take up that very last point first.
That was a throwaway. Answer the first part first.
I'll answer the first part first. Yes, the case law has said that just because a criminal conviction might result in termination from employment, that alone does not mean automatically pension forfeiture. But that's all the case law says. It doesn't say, keep in mind, that it is almost inevitable that if a public employee commits a crime, they're likely to lose their job. So there's always termination involved in these cases. So it's all nice to say just because there's termination doesn't mean there's pension forfeiture. That's true. But the fact that there is termination, and here the fact that there is termination under the specific terms of a statute, informs the analysis of whether the crime involves violation of the laws applicable and whether it undermines the fundamental tenets of the position. When the legislature says police officers cannot be hired if they have felony convictions, they are saying it is a central role of the police to be free of crime, off duty or on duty. And this court has said so in its decisions about this very issue about termination of police officers. So I think that's the answer to your question. I have to, on the excessive fine point, in Betancourt, this court decided that pension forfeiture is a fine under the Eighth Amendment and that it is subject to the excessive fine analysis. This is an important point. We recognize that forfeiture is potentially harsh and unfair in perhaps individual cases. But that should not cause the court to interpret the forfeiture statute in a way that makes it impossible to administer. Now that we have Betancourt in place, the harshness or potential fairness or not of an individual forfeiture is dealt with in the disproportionality analysis under the Eighth Amendment, which is essentially a fairness test. What Section 15.4 calls for is an application of that statute to individual circumstances based on all the facts and circumstances, but in light of the purposes of the statute. And as this court has said, the language is meant not to limit forfeiture to specific crimes. The legislature specifically intended that whether the crime involved violation of the laws applicable should be the test. And this court has put some flesh on those bones by talking about the central role, the fundamental tenets. But we should not be scared, if you will, to apply it in a way in which there are a lot of crimes ultimately, especially in the case of police officers, that may result in pension forfeiture. And that's because in Gaffney, the court said the legislature didn't intend any and all crimes to result in forfeiture. That's true. They included language that said not any and all crimes, crimes involving violation of the laws applicable. But the laws applicable, especially in the case of police officers, make violation of many crimes fundamentally contradictory with the role and position.
Can you think of any felonies that a police officer could be convicted of that would not result in forfeiture under this analysis?
I don't want to do that, as you can imagine, because first of all, it depends on all the facts and circumstances. There are a lot of crimes out there.
But if that's true, then it is all crimes that are potentially, all violations of law that are potentially putting a police officer at risk there.
Yes, yes. You cannot say that there's a one or two or a category of crimes that are off the table. That is true. It is potentially all crimes. But you still have to subject that crime to the analysis, but does it undermine the fundamental tenets, central role of the position? I say felonies go a long distance because of the specific statutes that specifically say police officers should not commit felonies. Those are laws applicable. If you commit a felony, you violate the laws applicable.
All right, thank you.
Thank you.